Well, welcome everybody to this CPD seminar on the public interest defence to defamation. I'm Professor David Rolph, and I'm from the University of Sydney Law School and an academic member of Level 22 chambers. I'd like to begin by acknowledging the Gadigal people of the Eora Nation on whose lands we gather, and acknowledge their elders past, present and emerging. It gives me very great pleasure today to introduce our speaker, Dr. Fiona Brimblecombe from the University of Manchester. Fiona is an expert in media law, has published extensively nationally in the UK and internationally on a large number of areas of media law, and is also the author of a book, Defamation in the Digital Age and the Right to be Forgotten, which was published last year to great acclaim. And I think you are also now, is this right, the editor of Communications?
Incoming, yeah.
Yes,
yeah.
The incoming editor. And so it's wonderful because obviously the public interest defence to defamation in Australia is relatively new to have the insights of Fiona on a defence which has had a lot longer life so far in the United Kingdom. And so Fiona will talk for approximately 30 minutes, and then Matthew Lewis of Senior Counsel, who will be well known to everyone in the room and most people online, will then provide commentary for about 10 minutes, and we should then have some time for questions from the floor and from YouTube. So I will throw over to Fiona.
Oh, thanks so much, David and Matthew and everyone for inviting me here. It's a real privilege and an honour, and it's the first time I've left Europe, I was saying to David, so to be in Sydney at all is amazing. So the way I'm going to pitch this talk is I'm talking sort of in broad strokes about the public interest defence to defamation. As David has kindly said, I have published on this quite a bit in the past, so if you want more specifics about sort of the English position and a breakdown in real detail of how these sort of decisions have been made in the court, I can provide copies of my work to anyone who wants them, and I'll leave my email address and you can just get in touch with me. And also a lot of the work is open access. I've just published an article in Journal of Media Law, it's fully open access, and my book is too. You can download the PDF for free. So yeah, if you're interested. So I wanted to sort of make sure we were on the same page before I got more specific and talk a little bit about the background to the public interest defence as it stands in English defamation law. So that's chiefly what I'm going to be talking about today. So forgive me if any of this is obvious. So traditionally what we would class as the public interest defence to actions in defamation evolved out of qualified privilege, which I know is much the same as over here. Although academics and judges, they all seem to have a consensus now that there's been a separation from that. We've seen that in Seraphim, which is the most detailed judgment we've had to date really on our now public interest defence in England. And the public interest defence, as we now have it really, originates from a very famous case in the English jurisdiction called Reynolds and Times newspapers from 2001, in which the Irish Prime Minister, the Taoiseach, brought an action against the Times newspaper for printing an article that said he deliberately misled the Irish Parliament. And in part, the decision took inspiration from Australian law, a decision called Lang, which I'm sure many of you are familiar of. And Lord Nichols of Birkenhead, who's one of my most favourite judges of all time, sort of laid down a very detailed decision in Reynolds. And he said that in determining whether the matter was covered by qualified privilege, that there were a number of factors. My professor, who inspired me greatly and taught law, Professor Richard Mullender, he called it a laundry list of factors. And these factors are really famous, and you see many of them in Australian law to this day as well, and in the English sort of jurisdiction. And they're things like seriousness of the allegation, the nature of the information, its source, steps taken to verify the information is really important, urgency of, does it need to be published now, or is the information going to wane if you have to wait, whether comment was sought from the other side and sort of included. Tone is really important, and timing. But this was the position at common law in England and Wales. However, it's important to acknowledge there were issues with how the defence operated at common law under Reynolds. So despite the fact we had quite a long list here, there was at least perceived to be sort of a lack of clarity about how the defence operated. And I pointed in some of my work in the past to certain famous cases that really illustrate that. So Flood at the Supreme Court is one of them. And you had a decision in Flood at the High Court, the Court of Appeal, and the Supreme Court. And there was a completely different decision reached in each one of those courts about whether the Reynolds defence applied for different reasons. So even our most senior judiciary couldn't make sense of it. Similar in another case called Jamil. And also, different academics over the years have had their views about the Reynolds defence. Some thought it went, too far, maybe it was too broad and all-encompassing. Academics like Gavin Phillipson of Durham and Bristol has argued that. And then others, on the other side of the balance, sort of more pro-free speech warriors like Ian Cram of Leeds thought, yes, the defence under Reynolds wasn't clear, but it doesn't go far enough to actually protect important speech. Interestingly, both sides of the fence there argued much the same thing for different reasons. Okay, there was this whole idea, there's a lack of clarity, this kept being said again and again. And then everything changed. So there was the libel reform campaign, which gained traction in the UK round about sort of 2010, 2011. And that lobbied for really quite serious changes to English defamation law, really major ones. And this movement was made up of a number of different sort of interested people and parties. You've got human rights campaigners, scientists, journalists, including Simon Singh, who himself got sued about an article he wrote about the British Chiropractic Association under a different defence, and politicians as well. And it got really prominent support from senior political figures, cross-party support, actually, in the run-up to a sort of general election. Nick Clegg, you remember him? He was sort of got behind this in a big way. Who was a leader of the Liberal Democrat Party. He became Deputy Prime Minister with David Cameron, if you can cast your minds back. Anyway, this movement was ultimately successful, that's the point, in securing new legislation that reforms the position in England and Wales, which is the Defamation Act 2013. And that does lots of different things. So if people want me to talk more broadly about other changes under that act later, I can, but I'm just talking about the public interest defence chiefly today. But the takeaway really of that reform is this. The effect is to water down the reputation protecting power of English defamation law. Now, I've made this clear in things I've written. I think that was a real mistake. I think some of the claims were overblown and were sort of quite exaggerated. There were sort of words being thrown around like, English defamation law was a global pariah, something that Phillipson said in terms of how far it was protecting reputation rights. And I don't think that that's true. If you look at other countries around the globe, for example, in Asia, many still have criminal libel. That wasn't the case sort of in England and Wales even then. And, pre this reform in 2013, it still wasn't easy to bring a claim. It's expensive. You had to meet an inbuilt severity threshold, which has actually got higher since the reform, which is something David writes about a lot. Statements have to be defamatory. You've got to have identification, publication, which is effectively communication. And then there's an absolute raft of defences. It's the only area of English tort law I spend as long lecturing about the defences as the substantive action itself. And this raft of defences has only been added to since this reform. But I think the purposes of today, one thing that this reform did is it put several common law defences on a statutory footing, and one of them was Reynolds, right? So the public interest defence. And in my view, codifying these sort of common law defences also wasn't really necessary or helpful. I always think that this sort of little things please little minds, this idea that, because it's a common law defence, maybe it's got less teeth. That's just not the case in my view. And maybe that's, from a perspective of people who are maybe a bit more unfamiliar with the common law system, judge-made law. And also common law has the advantage of flexibility in hard cases and nuance that black letter statute can never get to, in my opinion, because it's battered by both houses of Parliament. And, you know, in fact, I think there is a fear that statute can be too inflexible, so then stuff's just not included that needs to be. So, yeah, one of them, the things this reform did was to put the public interest offence into statute. So Reynolds was abolished under a Section 4 of the Defamation Act 2013, along with all of its case law, of which was extensive. Right, even in that short time, you know, in those years between 2001 and 2014, that it had existed really proper. And now we've got Section 4, which is very similar to what Australia has in 29A of the 2005 Act. So it's called, I mean, really, I should have brought a little slide maybe and showed you Section 4, but it's very similar. And I'll read it. Publication on a matter of public interest. It's the defence to an action for defamation for the defendant to show that the statement complained of was or formed part of a statement on a matter of public interest. The statement's got to be on a matter of public interest, and then the defendant has to reasonably believe that publishing the statement was in the public interest. Exactly the same as 29A. So that's where we're at in England and Wales now. And there are a couple of things I want to note about this reform that I think are wrong, aside from the fact that we didn't need it, in my opinion, to begin, which I'm sure you're getting, right? Okay. Firstly, it's extremely short. The main body of the information in Section 4 is 200 words long. It tells us, as I've just said, the matters got to be on public interest and got to be reasonable belief, and that's about it. It really doesn't tell us very much more. It abolishes Reynolds, all this case law, as I talked about, where you've got very senior, often members of the judiciary who are experts, talking about what makes up that defence in a very sort of detailed and nuanced manner. It was also a very active line of case law. Cases at high courts were coming all the time, refining the scope of the defence, adding more information. And also there's another confusing element to all of this, which although Reynolds is abolished, right, the explanatory notes to the 2013 Act, which is the reform, state that the old case law can be used by judges going forward in a sort of quasi-advisory capacity to help interpret the new defence. So they're no longer binding authority, but they still can be helpful and used. Well, what was the point of the reform then? So it becomes circular. But you know what? To me, that inclusion says a lot. Yeah, in the explanatory note. Legislators knew really, I think, that measly little paragraph wasn't enough to replace all of that common law, expert made by judges, that came before it. So instead now we have this strange halfway house, where it's abolished but kind of not. Right? So I'm sure it won't surprise any of you to know that we've got issues now, because, you know, this law came into force. It was on New Year's Day 2014. So, you know, we've got sort of more than a decade now under our belts, which for English law is small fry. You know, it's still new, but we've had cases, right, and certainly more than here. And I also want to caveat what I'm about to say with something else, which, yes, I think we've got issues arising out of Section 4 and the reform that's happened, but also some of these issues might have arisen anyway, because I think the world is changing and the way people are defamed is changing with the nature of the internet and social media, and that's something I've written about quite a bit in my book, actually. So the first issue I want to talk about is a lack of judicial understanding of this reform in Section 4. So as I've alluded to, sort of post-reform, there's now a real lack of clarity around what Section 4 entails. Can responsible reportage still be used as a standard under Section 4 or not? Well, some judges are using it as a standard, and I've set that out in an article I wrote in the Torts Law Journal. They're still busting out the list from Reynolds. Some of them are still using it in quite a comprehensive way, or at least parts of it that are possibly the whole decision is turning on, right? So even if they're not using the whole list, they're importing certain criteria very often into their decision-making in a regular fashion. And Matthew and I were talking about this before. I've noticed that verification of information, seeking the other side of the story, tone, is really important still and used a lot. How diligent have you been in your own research as a defendant, however that research might look? Also, you know, something can't be a purely personal attack, but it has to have some broader public interest value as well. It doesn't matter if you have personal views about that person you're writing about, as long as it contributes to a wider sort of matter of public interest. And that was the difference. We've had two quite high profile cases on this matter not too long ago. Hay and Cresswell and Aronson and Stones, and one was successful in making out the Section 4 defence, Hay it was, and in Aronson he was unsuccessful, the defendant. And that distinction was sort of crucial. It was also talked about in a very recent case in England called Miller. So I guess where I'm going with this is judges are in this no man's land, right, that no one would envy them of, right? We know that it's been abolished, but it hasn't really because of the explanatory notes. And you can still use the list, but you shouldn't really, Lord Wilson says, in Seraphin, which was our first sort of Supreme Court decision that really dealt with this in detail. And Lord Wilson is a gentleman and a scholar, you know, the judgment is fabulous. But my criticism of it is he does not do enough to explain where we're going to go next. He stops short of going, do you know what? In fact, these are the tools you need going forward. He says, look, this has changed. This laundry list shouldn't be used like a checklist. Well, it kind of never was supposed to be anyway. But stop doing that. But he doesn't help that much with what they should be doing. So we've got this lacuna in the law. And I don't think it's going to get any better until we get a more detailed explanation or advice from a very senior court that's going to fill that gap. I do feel sorry for the judges. I think they're clutching at straws a little bit, and it's only going to get more incoherent until we get more sort of advice from a senior court. Maybe that new advice might take the form of another list, and weirdly we go from list to have another one. But the advantage of that would be it would be a more modern list. I don't think that list would ever look the same as Lord Nichols of Birkenhead's list originally. Because as I said, I think the way that defamation is sort of being promulgated now has changed with the advent of the internet. And that list could do with an update. So maybe that would in fact be a good thing. Because this reform is not going to be repealed. It's not going anywhere. So the judges are going to have to do something with it. So we wait for that, I think. The other thing I'm really interested in at the moment, and I'm writing a chapter on for an edited collection I'm doing, is this idea of citizen journalists and this defence. So quite how broad can this defence now be extended? So now we know it's not really about responsible journalism. The standard is different, it's more flexible. So if I were to make a prediction, I think the area to watch really about Section 4 now is to what extent citizen journalists can and are going to be able to rely on it, and how that's going to look actually in the law, how it's going to operate, how broadly that can be interpreted. And I think maybe we should remember that, are we now travelling quite far away from the original purpose of this defence in the English jurisdiction, which was really to protect responsible and in many ways professional journalism? And I think this is a particularly pertinent question because a lot of defamatory statements are being made on social media by largely sort of private actors. And if you look at a lot of the big cases in England and Wales we've had over the last couple of years, you know, Vardy and Rooney, lots of you heard of that, or Wagatha Christie, you know, Hay, Stocker and Stocker, Banks and Cadwallader, I could go on. It's social media is involved, right? And obviously we all know the risks that come with that. It can reach a global audience, it gets tons of hits, it can go viral, how damaging that can be for someone's reputation. And I say this in my book, that I think the internet to defamation law is almost been like what the printing press was back in sort of the 15th century. It's changed everything once again in terms of how much harm can be done. And I think that the courts, certainly in England and Wales, are going to have to step up to meet that new challenge, or I hope they're going to anyway. A lot of these people who are writing potentially defamatory information online could be classed as citizen journalists, I think. And this is exacerbated by the fact that there's no one clear agreed on definition of what a citizen journalist is. Lots of people might class themselves as lone wolf reporters who are looking to get the truth out there about important news pieces and using the internet to do it because it's free, it reaches a global audience, it makes sense. And, you know, recently I was reading a Council of Europe technical paper, and they seem to be in favour of not, in fact, giving a clear definition of what a journalist is. They favour what's called a functional approach to the issue. In other words, you look at what that person is doing rather than who they are. And I think that's the, you know, the sort of way forward that it's going to be in the English courts as well. And interestingly, Ian Cram has noted in the past that who can be classed as a citizen journalist is actually a question of the public interest anyway. So in a way, the question collapses in and of itself. It's interesting. And, you know, the phrase citizen journalist keeps cropping up in the Section 4 case law in England. It was mentioned a lot in a case called Packham and Whiteman, which was decided not too long ago about a quite a well-known TV presenter, and also Miller and Peake. And it seems to be something that defendants are now using to argue this phrase citizen journalism, I'm a citizen journalist, to arguing that they should be caught under the auspices of the Section 4 defence. And my question is, how far does this Section 4 defence now extend? So many people can be classed as citizen journalists. And in a sort of seemingly benign way, have we thrown the gates open wide for this defence now to be used by anyone? Now, this idea of responsible reportage has been jettisoned, supposedly. I mean, the very purpose of the reform in Section 4 was to make it more flexible, more readily used outside of mainstream journalism. That was clear from the parliamentary debates. But quite how far is this going to go, especially when the nature of journalism is changing? And I think that as a result of all of this, we've thrown open the gates in terms of who can rely on the defence. There's now pressure on the courts, I think, to restrict Section 4's scope in other ways. I think they're going to have to examine this idea of reasonable belief in a very detailed and almost quite strict manner, and possibly also the notion of the public interest, potentially more narrowly, if the scope of this defence is not to get sort of out of control. Standards of pseudo-journalistic behaviour are already being examined. You can see that. Another question that I've asked myself recently, and in the more recent article I published in the Journal of Media Law, was, does Section 4 change depending on the defendant in question or the statement in question? Well, this is one thing I've started to see happening that I wasn't expecting to see, but is perhaps controversial. It's changing sometimes in how it functions depending on the context. And interestingly, this is something that came up at bill stage for this raft of reforms in 2013. And in the select committee, there was a joint committee between the House of Commons and the House of Lords that had academics on it as well. And people raised concerns about this because some people wanted the defence to be more lenient if you had less resources as a defendant, so to be more flexible in that way. But that was pushed back at in quite a lot, especially to the chagrin of a lot of pro-reputation academics. Now, formally in practice, the official line of Section 4, and the judges have taken on this, is that it shouldn't change. Yeah, Section 4. That in fact the standard shouldn't be wavered depending on sort of who relies on it, citizen journalists or professional journalists, for example. And that was confirmed in Miller recently. However, what our judges say and what they do often are two different things. So although it's early days, I would say I think Section 4 sometimes is somewhat of a chameleon. It can operate differently depending on sometimes what the statement is. So, for example, if that allegation, defamatory allegation at issue, is one of sexual misconduct and therefore very serious, striking to the heart of one's personality, life ruining, it would seem that Section 4 is only often successful if the truth defence is also successful. Which is interesting because only one needs to win, right, to be successful for you to sort of be protected. But there's this weird symbiotic relationship being developed by those two defences, truth and public interest, in those types of cases. And as I say, I discussed this in the Journal of Media Law article. Almost like the courts are constraining the new defence's operation by virtue of importing new thresholds into it without really being explicit about it. You see this in Hay and Aronson, 2 cases I mentioned recently, that both involve allegations of sexual violence, sexual misconduct. On the other side of the balance, it seems that in some circumstances, the courts are also more sympathetic with certain types of defendants who is bringing the action, rather than the statement itself. We've got contributor immunity now effectively under Section 4. That came out of a very famous case, I'm sure lots of you heard of it, called Economou on Rue de Freitas. So in some circumstances, if you've got less resources, perhaps less is expected of you regarding sort of diligence of checking before you sort of speak to the media or publish something yourself. And possibly also, I think, demonstrated a level of sympathy if you're an alleged victim or involved in the complained of matter, which is often very serious yourself closely. You're speaking to your own personal experience. Yeah, that's the case in Hay, and to an extent Economou. He wasn't involved personally, but sort of through family. And another thing that I think is one to watch for the future is impact of the internet. I think there's a real uptick in individuals running the Section 4 defence in respect to online posts. I mean, in some ways that's not a change because it's normal in England and Wales, and I'm sure it's the same in Australia, to sort of throw a lot at the wall and hope something sticks, run lots of defences, and maybe we'll get the jackpot with one. This has been exacerbated by the fact, I think, that more defamatory posts are appearing online than in traditional print media now. The way people consume information is completely different. News now people do through the internet, apps on their phone. And there has been success about running this defence in relation to online posts, Banks and Cadwallader, for example, and I think we're going to see even more of this in the future. But a lot of questions still remain, as I've alluded to earlier. Is reasonable belief assessed to a different standard for an online commentator with fewer resources? And also, can and will the concept of the public interest be interpreted differently as well in the context of the internet? Because we all know people want to read conspiracy theories, lascivious information on the internet, and they go to the internet to do that. It's more readily available there than anywhere else. So a lot of this remains to be seen, I think, going forward. And a final thought, because I'm sort of aware of time, I'm coming up to the end now, really, is that I wanted to have a think about, to sort of leave you, is part of the root problem here with all of this, because I've just absolutely slagged off a Section 4 and to an extent Reynolds for quite a while. Is part of the problem really at bottom here the nature of the public interest itself as a concept? It's certainly not all of the problem, but I'm increasingly, as I get older, wonder, is it part of the problem? Because it seems that nowhere can really get this right. I get the impression from sort of my very quick reading yesterday and a few days before of the Australian position that Australia is struggling with this as well. We've had problems, and now, given the state of English law, it's not so much with this defence a who can rely on it question, it's a when can it be relied on question. So the concept of the public interest itself, which is one of the 2 prongs, I think is now itself under more scrutiny than ever before, because it's one of the last bastions now to rely on this defence. It's one of the main ways its operation is going to be constrained. And, the public interest itself is an ephemeral concept, as we all know. It isn't always clear from judges how decisions are being made as to what is or is not public interest worthy. Certainly, in the English and Welsh jurisdiction, it's opaque. Sometimes a judge will just go, even in a brilliant judgment, otherwise, will just go, well, there is clearly public interest value in this information. They move on. Well, it would have really helped if you could have told the room why, And then, other than that, sometimes you get quite sort of asinine comments like, obviously, we all know there are certain things that obviously fall under the remit of sort of public interest value, like, for example, if someone's misuse of public funds or misconduct in a public office, they always get trotted down as examples. Okay, brilliant, we know that, but what else? And a lot of these sort of the law is hard fought on these difficult cases that are sort of in the middle. So we know certain things, but we still don't know an awful lot about this concept of the public interest. And Paul Ragg, who's an English academic who writes a lot about misuse of private information, which is our privacy tort in England and Wales, has commented that the public interest is a continuum, yeah, which I think is true. And I was also reading a little bit the case, your Australian case, Russell and ABC, which is one of your two big cases on your position at the moment here, which has followed our position quite closely, saying the categories of what could be constituted in the public interest are never closed. I think that's right. Actually, that's sort of the point. It has to be sufficiently flexible to do its job, this defence, lest it doesn't exist at all. But it would be helpful to know more. And I appreciate that's a hard ask. I've argued in the past myself about English privacy law, so not defamation, that in fact, sometimes too broad a concept of the public interest has been used, particularly in the mid-2010 privacy cases. I call them like the footballer cases, Terry Ferdinand, Goodwin. That's not a football case, but we can't make the same mistake with the Section 4 defence. Now, we can't afford to, because we've already opened the floodgates to some extent in other ways. Also, and David and I were discussing this last week, judges often talk past one another about considering what the public interest actually is. They assume sometimes everyone agrees or understands what they mean without explaining it in a sufficient way. And as a result, it's never properly defined. That, or they don't want to touch it with a barge pole, which also I understand, because that's quite a mantle to sort of to take on, to try and do that properly in a judgment. But that's my next big project for myself. I'm going to write a book. I'm just about to start it on, really an examination or an interrogation of what the public interest is as a concept across different areas of media law. Because also I think the concept might vary if we're talking about a defamation context versus a privacy context versus a data protection context. And I'm also going to look at Australia as well in a comparative angle, see if any new sort of light can be gleaned. That's all I wanted to say really, but I just also wanted to acknowledge that I'm an English lawyer coming, well, I'm Welsh actually, coming to Australia. It's this beautiful place to talk about English law and bore you. I did have a look at what's going on in Australia, and I want to do more research on that while I'm here. I haven't been here very long. But my very rudimentary understanding is that unfortunately you've fallen into the same trap. Yeah, you've introduced a defence that's very similar to Section 4 in 29A, as I said, certainly in New South Wales. It's called the same thing, publication on a matter of public interest. And all I've got to say about that is I'm very sorry. And I hope that your judges are going to do a better job, or I think our judges are trying as well, to be fair. I just think it's difficult. It will be good to have more case law from here to help us as well on this. Interesting, isn't this, that it comes in cycles, because Reynolds itself, the original position in England before the reform, drew on Australian defamation law in elucidating those factors I was talking about from Lang. But interesting, there is a difference from what I can see, because in 29A, from what I can gather, it does retain what I would call Reynolds factors in it, which is something we haven't done in England and Wales. And factors like sources, verification, expediency, severity, other side of the story, things like that. So in a way, you've stopped short of a complete overhaul, as it were, which was more what we've leaned towards in England and Wales. And I actually think this makes a lot more sense, and it will avoid some of the pitfalls that have happened in England and Wales, because you can see the English courts flapping with not really wanting to rely on the list but not having anything else. And because you've still got some sort of starting point here that's concrete, I think that will help. But I know that you haven't had that many, because obviously this has happened so much more recently here, that you're waiting sort of more judgments from senior courts. I've had a read of the two so far. Well, and by that I mean Russell and Almuderis. I was very interested to read Almuderis, actually. I thought a lot of what's said made sense in relation to sort of the new law, as it were, here. Yeah, and so I suppose my final comment to make about that is that, so the 29A defence that you've got now, it operates strikingly similarly to Reynolds, what we've moved away from, even though it uses a lot of the wording of section 4. It seems that responsible journalism maybe is still king here, less so, certainly, which position I think has been trying to move away from in England and Wales, which is kind of the point of the public interest defence to me anyway. Not the case anymore across the pond. Anyway, very interesting, so I'll leave it there. So thank you very much.
Thank you very much, Dr. Brimblecombe, for that rather fascinating presentation. The conception of not only that presentation, but also of your most recent published work is rather brilliant. And I'm not just saying that because I just learned your Welsh today. To cut to the quick, ladies and gentlemen, Dr. Brimblecombe's papers on public interest should be, in my view, the compulsory reading for all media practitioners. Perhaps we can make some copies available through our clerk, Jackie, and for those online, perhaps you can send an email in and we'll try and make them available. But as Doctor said, they are available on an open source basis anyway. Dr. Brimblecombe's work in this area is very much fills a lacuna in existing literature concerning the public interest defence in defamation and the role that the public interest plays as well as in other areas of the law. And as we all know, allegations of wrongdoing sit at the centre of many modern media landscapes, not just in Australia, but around the world. The reporting of such matters engages a dense intersection of legal doctrines from defamation, privacy, breach of confidence, and the principles bearing upon fair reporting of court proceedings. At the same time, of course, public interest journalism remains indispensable to the proper functioning of a democratic society. It informs public debate, scrutinises power, and promotes accountability, all of which I'm sure many in the room know all too well. But what emerges is an increasingly complex and evolving legal terrain in which competing values, reputation, privacy, open justice, and the freedom of expression must be carefully analysed and scrutinised. Now, the UK in this regard is, and on one view, streets ahead of us in Australia. The public interest defence in particular was introduced there, as Fiona said, a decade ago, over a decade ago. And there's been a plethora of case law with respect to that, the operation of that defence. Similarly, the public interest has played a significant role in determining whether publications would amount to a breach of privacy in that jurisdiction. Now, considering that our public interest defence and the statutory tort of privacy are in their infancy, Dr. Brimblecombe's work and recent papers are rather prescient for those of us in Australia. And they make a valuable contribution, therefore, to the perhaps never-ending debates that we have and enjoy in this area. They illuminate both the doctrinal tensions and the practical challenges faced by courts and news media organisations alike, and they provide a clear and thoughtful framework for navigating that intricate web. Now, as I've already noted, with respect to defamation law in Australia, the public interest defence remains but perhaps a toddler. Ever the child prodigy, His Honour Justice Lee was the first to take the defence out of its pram and give it a close inspection. Russell against the ABC has, for the most part, perhaps been viewed as the wrong vehicle for the defence. It wasn't surprising, for example, when we all learned that the defence failed. However, there are many positive notes from what His Honour said in that judgment. Consistent, for example, with Parliament's intention, His Honour emphasised the difference between, on the one hand, the public interest defence, and on the other hand, the notoriously technical qualified privilege defence. And as Dr. Brimblecombe has explored in her papers, that fact alone is something which early decisions in the UK have perhaps arguably failed to grapple with. Most recently, of course, Justice Abraham in Almadiris enabled the toddler defence to walk and talk, and the Nine Network perhaps might be forgiven for looking on it as a rather proud parent. But it remains to be seen whether the full court will turn those parental smiles into frowns. However, for present purposes, it would appear that Dr. Brimblecombe, I told you I was going to trip over that, thesis has survived the tyranny of distance. Both Russell and Almadiris arguably fall into the first of the two approaches adopted by the UK courts and which Dr. Brimblecombe has identified. Namely, they are process-driven, choosing to focus on responsible journalism rather than adopt the second approach, that the journalism in each case is broadly public interest worthy in any event. Now, anecdotally, and having regard to the manner in which courts have previously approached public interest journalism informed defences in Australia, it is perhaps rather unlikely that a judge here will adopt a public interest defence so broadly as has been the practice in recent decisions from the UK. With respect to privacy law, of course, the Australian tort again remains in its pram. Now, to date, there's been no recorded decision that we can discuss. And of course, the exemption for journalists under Clause 15 of Schedule 2 of the Privacy Act means that it is unlikely that in Australia we'll be met with the torrent of cases that the media were met with in the UK. So surprisingly, a respectable argument might be advanced to say that the public interest is better protected here than there at the moment, at least for the time being. However, in that context, Dr. Brimblecombe made an interesting point in some of her recent papers that have been published in the Journal of Media Law, which haven't really been delved into today, but I would encourage you to look at. The specific point which is made is that the public interest both serves to protect and hinder specifically women making sexual misconduct allegations. And that is a point which will not be lost on Australian practitioners. Traditionally, injunctions have frequently been obtained in Australia by men and women alike to constrain publication of private, intimate information leaked online by example only. There are some examples well known in the law reports, Giller and Prokopitz and Wilson and Ferguson being but two of those well-known examples. But there are many more, and the details of which, of course, are generally suppressed. Like in the UK, Australian courts have sought to protect in that capacity human dignity and have recognised that there is no public interest to that sort of publication. However, on the other hand, it is not uncommon for some powerful entities or organisations to use the law of confidence and other means, including court procedures, such as the federal court rules, by way of an example, to silence allegations involving sexual misconduct. An example of the former kind is Seven Network against Harrison. Some of you in the room might remember that from 2017. There, a confidentiality clause in a deed of release was used to constrain what Ms. Harrison could respond to in the media. And you might remember that there were allegations that she had to meet that were being made by those more senior and more powerful than her from connected to the media organisation. In the end, the court determined that public interest favoured suppression rather than the ventilation of those allegations. With respect to the latter, which is namely the federal court procedure, there is a growing body of case law in the federal court that prevents journalists from accessing pleadings filed in, for example, Fair Work cases, which, as we all know, often contain allegations of sexual wrongdoing. The court then tends to suppress the allegations and allow parties to mediate. Some cases subsequently settle, and those that do settle are met with wholesale suppression orders. The public interest in reporting those allegations consequently very much takes a back seat. That is, I think, a concerning development that will have to be confronted at the appropriate time. That is for another day. For now, perhaps all I have to do is thank Dr. Brimblecombe for her presentation, for highlighting so clearly some of the differences in approaches between the UK and Australia in terms of the public interest defence, and thank her for her insight and valuable nuggets of wisdom.
Well, so this leaves us with about 15 minutes for questions. So I have one, but I will hold on to that in case there are questions from the floor or online.
How do you think a lot of commentary mostly online these days, and often the most insightful commentary is satirical websites, so we have the Batuta ad, and I think there's the Onion in the States, and then we have the UK. How do you think a post that, you know, is defamatory might be treated by the public interest defence if it comes from that satirical context?
Well, often satire is interesting because the point of it, isn't it, is that it's actually making a broader commentary about what's going on in society that in fact can be deeper cutting than a serious piece of journalism, which is sort of the brilliant bit about it. I always think about, I don't know if you've heard of Private Eye, which, you know, it brought to light some absolutely just, well, the post office scandal, the Private Eye never dropped it. But even before it was sort of became back fashionable with the TV series and things, because it felt so strongly. So I think definitely if a post like that was public interest worthy, was because what the words you often see mentioned by judges to this effect is, are you contributing sort of to a discussion or giving information to the public at large that is public interest worthy? And this sort of terminology was coming out in Hay and Cresswell because it was about Me Too. She wasn't just talking about something that had happened to her, but also worrying about what might happen to other women or the potential victims in the light of this broader sort of socio-political movement. And it was that link between what she was disclosing about her experience and the movement that crystallised the section. So if you could make an argument like that, and I think with a lot of satire, possibly you could. There's also
you'd be unable probably to, you know, if you were applying some kind of a checklist to satirical websites, are likely to put the allegations to the other side and probably unlikely to tick off the responsible journalism.
Well, it would depend.
Okay, yeah.
It would depend. If it was something like Private Eye, the journalism's very good. So yeah, and it's more than just putting the other side of this. You know, this checklist is very long now, and in fact, I wonder if now under Section 4 you could argue it more easily than under for that reason as well, because it's supposed to be slightly broad. So it would depend on the facts completely, but it's interesting to think about. Yeah. Thank you. Go on, yeah.
So, I mean, I don't want to put you on the spot, but so you did have that wonderful sort of bit where you sort of said that perhaps the sort of Lord Nichols list of factors might needed to have been updated for the internet age. So if you're updating that list, what factor or factors do you think? So,
oh, well, the thing about the Lord Nichols list, as I said, it sort of draws from other cases, including ones over here, is that it's thinking it from a context of traditional sort of broadsheet journalism. And I do think in terms of the diligence of reportage, maybe that needs to change, because that whole list is about diligence of reportage. And I think that any modern list, if we were to have one, again, call it that, would need, David, to have things like verification. How much research have you done? But I also think it would need to reflect the research maybe looks different now. And in fact, you know, how a citizen journalist or someone operating with the best intentions online and working very hard to find out certain facts and information, maybe in fact they can only get certain access to particular types of information that maybe a professional journalist in a traditional setting could not. So maybe that would need to be taken into account. I think also, given the nature of the internet, because you know my position on this, it's very sort of pro-reputation really in a lot of ways, so I'm looking at it from this angle. I think also it would need to take into account still the severity of the allegation, which is something that you see sort of reflected, I think, more in the Australian position. Because I think almost something posted on the internet can be more damaging even, because, you know, what's that old adage? Today, you know, today's newspapers, you know, tomorrow's chip paper. That's not so much the case online. With the way algorithms work, information can be sort of dredged up at any particular point. It can go viral much later in time, and it can reach a global audience. So I think that would need to be reflected. Like the level of reputational harm can actually sort of vary with the type of a publication and where it is on the internet. I think tone is still important as well. That is still alive and well under the modern reading of Section 4, right? What are you actually sort of trying to do? And this might even go into your question a bit actually as well about satire. Also, yeah, so I think it would need to take into account the technology in a much greater way. But I do think it would need, if we're going to constrain the defence appropriately, you would still need some element of journalistic standard in there. I'm worried we're going too far away from that, possibly with what's happening in Section 4, but also with an appreciation that journalism looks different now, or in fact investigating rather, even if you don't want to call yourself a journalist in good faith, looks different. Yeah, and wanting to put information out there for the public good. Yeah. But do you know what? That first article that I wrote that we were talking about earlier, that puts the two sets of case law in different categories, one sort of orthodox and one not, under Section 4. There's a part 2 to that article that I haven't written yet, which is what is the new list? So I am sitting on that like an egg and trying to work out exactly what it should look like, because I sort of feel like I need to think carefully, because I have slagged everyone off and said they're doing it wrong, which then in fact makes more pressure on me of what exactly is the right. And I've got some ideas.
You don't have to come all the way.
No, yeah. But that is the question. And in fact, I think I've said we need authority, from a senior court on this. I don't think we're ever going to get a list like this, like a laundry list again. And I think the reason, or not for a very long time, and I think the reason we won't get that again in England and Wales anyway, is because the whole point, if you read the parliamentary debates, was this list bad, list is too inflexible, right? Whether I don't think I agree with that actually, but that was the gist of why we needed the reform. So I think rather than maybe a list, what we'll get is emerging patterns. And then we can say there's a factor here. And I wonder if we're getting patterns already. Like, for example, what I said before in the article Matthew was talking more about sort of sexual misconduct, when you've got an allegation of a sort of sexual violence or serious sexual misconduct. In fact, a factor that is emerging now from Section 4 in lieu of a list is there substantial truth to that allegation as well? So that, and it seems to be, if the answer to that is yes, and they can always, English judges always consider truth first, it goes chronologically, then almost the Section 4 argument collapses into the truth defence argument. It's easier to make out both of the limbs, public interest and reasonable belief. Although I do speculate on in that article as well, is that also because sometimes the facts just make it easier to argue both at the same time, rather than in fact there's an interrelation. But I do think we will see almost like a symbiotic relationship between truth and public interest in certain types of cases, in those ones. So I wonder if that is a new factor maybe we've got with Me Too, with how society's changed, with and all the information on the internet through that. So.
And I suppose in the Australian context, there's sort of the experience of our sort of pre-public interest defence, so statutory qualified privilege, truth, or the truthiness of what has been published, had a sort of material impact on statutory qualified privilege and the outcome. The closer you could get to demonstrating that what you published was true, the more likely that you'll get statutory qualified privilege across the line. And of course, the whole purpose that you would have a sort of fallback defence like that is that you can't discharge the previous onus to justify the publication. So yes, that's I think very interesting.
It's also, as you say, it's a strange phenomenon, isn't it? Because the whole, and I say this in this speech, the whole point of having a public interest defence, so having Section 4 and having Reynolds, was that that's the net. If you can't prove something conclusively to be true, but it's still so important, it needs to be out there for the public. So to then see them relying on one another, in my interpretation in those two cases, is interesting. And I wonder if we will see more of that, but particularly in allegations of sexual misconduct, I think. I've not seen it in other areas anywhere near so much. And I wonder if that speaks to the severity of that particular allegation. Yeah. Interesting.
I did have one more question, but all right, I'll ask it.
I was going to ask, the most recent case that I'm aware of in the UK that deals with public interest defence is obviously Clark and The Guardian.
Yeah.
At least I think it was the last case that dealt with it. And I wanted to know what your view of that was, because it sort of lends into this argument of truth merging with the public interest defence, and where you see that sitting in the collection of cases that you've analysed with respect to the two approaches?
I think we're moving, since Seraphim, I think there's been a real trend to move more towards away from the orthodoxy. I don't think the courts now want to sort of use the list, because really Lord Wilson has said, please don't do that. Although it does make sense for certain, parts of the list naturally, as we said before, to come into the mainstream. Like verification is always going to be quite important and things like that in certain types of cases. And in more sort of unorthodox, maybe cases more online outside traditional mainstream media, or the new factors will have to be used. So I think that in general, the trend in the last year or so, I would say, in all the cases I've read on this, is they're trying to move away from traditional Reynolds and embrace a broader sort of scope, but not really being able to free themselves from that. So I wonder to what extent in the future, I think it will take a very brave judge to go, in fact, this is completely the new order. But I think we're still waiting to see that, even with the recent ones. What do you think about?
I actually thought it was a really interesting judgment. I think the right result was arrived at.
I do. Yeah.
And that it was a public interest journalism. But they, to your point, the court went through truth first and found essentially that it was true, and then found it was public interest journalism. Although interestingly, I thought that the judge who was dealing with it first instance, there was a throwaway line where, a little bit like your point that you raised in one of your articles about Justice Williams, where he says, well, of course this is public interest. There's a similar kind of line
Attitude,
in Clark, where they said, well, obviously this is public interest, and now I'm just going to tell you why. and then it goes into, I think it's 800 odd paragraphs as to why, not too dissimilar to our Almadeus in some respects, although Almadeus does go on for longer. But I thought it was an interesting decision. But I thought it probably fell in the category, I suppose, that you've identified of distancing the court from the Reynolds
I think that's right.
criteria. But still, there was reference.
They always,
reference to it in a number of, but it's becoming more infrequent in the judgment. Whereas before, I think the early decisions were, this is what Reynolds said, these were the principles, and I can't apply them anymore, but I'm going to do this one. Whereas now it's sort of, well, of course we can't apply that anymore, but we can draw on those principles to a certain extent, and that's what we're going to do.
And I think that that's a good thing. I think the courts have felt under huge pressure to do that since Seraphim, and some have been better than others in doing it. Because they want to sort of give effect to what Parliament wanted with sort of changing the law. And that was the point. The point was, okay, the list is still, can be used, and organically, as you said, sometimes still will be, different bits of it will be relevant, but we want to sort of move away from it more categorically now. And I think that will continue to happen, but we could do, I think, with more guidance. But yeah, I wonder if that also speaks to truth in Section 4 working together. Yeah.
Thank you.
All right, well, I note the time, so we should probably wrap up. So can you join me in thanking Fiona for